Hi, my name is John Landy. I'm an emeritus professor at the University of Missouri Law School, and I am going to tell you why I think they should call it negotiation school and not law school. This is a talk I'm doing for Professor Becky Jacobs' Alternative Dispute Resolution course at the University of Tennessee College of Law, and I hope you find this useful. All right, so what we're going to talk about today, we're going to talk about what I call the wrong end of the telescope view of legal education, problems with traditional negotiation theory, alternative theoretical tools, and I want to highlight the importance of this concept of theoretical tools. Theoretical tools will help you in practice, and they say there's nothing more practical than a good theory, and so I think we have some tools here that will help you. I'm going to give you some tips for practice, some practical resources for further learning. And Professor Jacobs will give you a copy of this PowerPoint with lots of links, so you don't have to take notes and you can follow up some of the points we're dealing with. So do you want to know a secret? Secret is that every law school has what educational experts call a hidden curriculum, which is very misleading in law school. And what is the hidden curriculum in law school? It's that legal rules are the most important factor in disputes. Most cases are decided by appellate courts. And thinking like a lawyer, that's what we're supposed to be teaching you. That's what it's about, is predicting court decisions. That's what it means to think like a lawyer. And winning is the most important thing, or the only thing. And it's all about the money. Lawyers and clients have the same perspectives. And clients are mostly invisible bystanders in their cases. You rarely see them in these cases you read about in your textbooks. And negotiation is trivial. It's barely worth mentioning. That's what the implicit message is in most law school curricula. And can you handle the truth? Do you want to know the truth? Well, here's the truth. Truth is that legal rules are not the most important factor in resolving disputes in many cases. This is a link here to an article by a magistrate judge who has conducted thousands of settlement conferences. And he describes all sorts of other factors that are really important in resolving disputes. And you know what else? Most cases are not decided by appellate courts or even trial courts. And yet your case books have all these excerpts, easy for me to say, of appellate court decisions, which gives the impression, the implication that that's where the action is. That's where most cases are settled, but that's not the truth. And thinking like a lawyer is focusing on your client's interests. It's not just or even primarily predicting what's going to happen in court. That's an important factor, but that's a tool in the interest of satisfying your client's interests. And winning often is not the most important goal for clients. Often it's not losing. They're afraid that they're going to have bad things happen. And so they're looking to avoid that. And there are lots of other things which we're going to talk about shortly. And it's not all about the money in many cases. One of the things you will learn, you probably learned already, is that courts generally monetize disputes. They're going to, mostly what courts will do is provide some monetary relief. Sometimes they'll provide injunctions or declaratory relief, but you're told, and accurately, that this is not the norm. And so most lawyers will monetize disputes and tell clients that that's what it's about. But for clients, that's not what they're often concerned about. They're concerned about a lot of other things in addition to money. And not only that, lawyers and clients often have very different perspectives. This is a link to an article by someone who's collected lots of research about how clients are extremely frustrated with their lawyers because they feel that they don't listen to them. They'll say their lawyers are worthless. And this is true for both clients who are individuals and organizations. And lawyers often are frustrated with their clients who they feel are unreasonable and aren't focusing on the legally relevant issues, all these other things that the clients are concerned about. They don't understand what's happening in court. So they often have very different perspectives. And clients are the central actors in lawyers' work. One good reason They're the ones who pay your bills. Judges, courts don't pay your bills, clients pay your bills, and lawyers beyond that want to try and satisfy their clients' interests. That's what our goal is as lawyers. And lawyers negotiate all the time, much more than appearing in court. So that's the truth. And this hidden curriculum that provides alternative, different stories is very misleading at best. So part of that misleading story is that trial is the real, is where it's at, but it's really the alternative dispute resolution. You're taking a course on alternative dispute resolution, which focuses on negotiation, mediation, arbitration, things like that. That's where most cases are settled. Trial and appellate cases are the real alternative dispute resolution. In federal courts, only about 1% of lawsuits go to trial. In state courts, sometimes it's somewhat more, but it's still a very small proportion. And these statistics don't even include all the cases where they're settled without a lawsuit being filed. So lawsuits are a small proportion of the cases, and that's why I refer to the wrong end of the telescope. Here's a quote from an article by two very prominent law professors. They say, tried cases typically are high risk, all or nothing cases, cases with unusual facts or intransigent parties, cases that defy compromise. Their outcomes, by comparison with ordinary workaday settlement cases, are costly, unpredictable, and sometimes bizarre. Because jury trials and jury verdicts are the most visible products of litigation, these extreme and unrepresentative cases distort public perception of the administration of justice. I would just modify that by saying that actually appellate decisions, like with the Supreme Court, are the most common perceptions, public perceptions of what's going on in the courts. And that's even more of a distortion, because only a fraction of tried cases are appealed. And of those, only a fraction of those are decided with a written opinion. So you're looking at a very tiny proportion of disputes, and you shouldn't get the misimpression that that's what most of what lawyers do is. And so how can you use this information? I'm providing this to you to give you context and help you understand what you're learning in law school. And I want to emphasize that litigation is essential for many reasons. It provides an important way to resolve public and private disputes, particularly if people can't do it on their own. It's a way to establish public norms. It's an essential part of our society. It's also very problematic. It's one that people should avoid and minimize if they reasonably can. So as you read the cases in your courses, in your case books, imagine what was really going on between the parties, because the recitation of facts is very narrow and limited and focusing really only on the legally relevant facts, when in fact there's a whole drama that's going on that's completely left out. And since few cases go to trial or are appealed, ask yourself what was different about those cases that you're reading about than the vast majority of cases that never go to trial and never are appealed. And why did lawyers make conflicting legal arguments? Are they because they're so stupid? And are lower court judges stupid? No, they're not stupid. Why do their cases, why do their decisions get reversed? Think about that. So now I'm going to shift to negotiation, since that's where most of the action is. Now, there are lots of different definitions, and there's no consensus about what negotiation is. My definition is negotiation is a process of seeking agreement about a course of action. Now, unlike some definitions, this doesn't require that there's a dispute, doesn't require that there's bargaining, doesn't require that there's an exchange of offers, doesn't require that there's legal consideration or quid pro quo, doesn't require that there's a goal of forming a legal contract. Now, in your contracts course, these various elements are discussed and may be required, and there's a good reason for that. The courts don't want to get involved in adjudicating all sorts of agreements that they can't and shouldn't handle. They have limited resources, but parties and lawyers negotiate and reach agreements in lots of cases that don't include these elements. So there are transactional negotiations that don't involve disputes. There are negotiations that don't involve exchanges of offers or bargaining. So instead of thinking about negotiation as a process that necessarily includes some or all of these elements, think of it as the more limited concept that I describe of a process of seeking agreement about a course of action. And then you can talk about some of particular types of negotiation, dispute negotiations, or negotiations that do involve exchanges of offers, or negotiations that do involve a goal of forming a legal contract. And in fact, lawyers negotiate all the time. People think of negotiation only as a process with a counterpart lawyer at a final stage of the case. And in fact, lawyers also negotiate throughout cases with clients, with supervisors, with coworkers, experts, court reporters, private dispute resolution professionals like mediators and arbitrators, and even judges. So let me give you some examples. Lawyers seek agreements with clients about fee arrangements or the scope of work. One of the things that's important for you to know about is a concept called unbundling or limited scope representation. And so what that means is that sometimes lawyers only handle certain tasks that they and the clients agree about. So that's a form of negotiation. Obviously, fee arrangements are some things that lawyers negotiate. There are a lot of things that lawyers negotiate with their clients. Lawyers negotiate with counterpart lawyers about all sorts of things, such as extensions of deadlines. They negotiate about discovery requests. Often there are disputes about discovery, and so they'll negotiate about coming up with some discovery plan. Lawyers negotiate with their supervisors about what arguments to include in a brief. They negotiate with coworkers about what to order for lunch. Negotiate with experts about what to include in an opinion letter. They negotiate with court reporters about scheduling. They negotiate with the mediators about what materials to provide. And they even negotiate with judges about a discovery schedule. And here's a link with an article describing a lot more examples of negotiation. Now, negotiation theory provides that there are two general models. And these models are confusing and misleading, and they have various names. Now, one model is called sometimes the adversarial or positional model. And in this model, parties try to maximize their advantage, starting with extreme positions. So you are representing a plaintiff and you think that your case is worth $100,000. You may start off with a demand for $1 million because you're going to recognize you're going to need to make a series of concessions. And the same thing for the defendant. So you're going to try and get the most for your client. You're going to start with an extreme position and make a series of concessions. The second model that's commonly taught is, again, uses several different names: cooperative or interest-based negotiation, and parties try to satisfy all parties by identifying the interests and options for satisfying all parties' interests. So at the beginning of the process, they may identify what their goals and interests are, and then they may identify a list of options for satisfying the interests of both parties, and then try and pick an option that best satisfies the interests of both parties. So those are the two traditional models of negotiation. And they're missing an important one that's more common, certainly, than the interest-based model in negotiation, and probably even the more adversarial model. And I call this model ordinary legal negotiation or norm-based negotiation, and it's based on a study I did of how lawyers settled recent cases. And in this model, negotiators start with generally accepted norms and argue for advantageous modifications. And let me give you some examples of this. In cases involving child support, states have child support schedules. And if you plug in the amount of income from the parents and the number of kids, the child support schedule will produce a presumed amount of child support. Now, sometimes there's no negotiation. They'll just simply accept that number, but often there will be a negotiation. The party receiving child support will say, well, I really deserve more than what's in the child support schedule, and they'll specify the reasons why, and the person paying the child support will argue that they should be paying less. And so there's a negotiation around this norm. It's also used in negotiations about parenting time, parenting schedules. So in most places, there are norms about a typical parenting schedule. Typically, kids will live with one parent most of the time and will be with the other parent every other weekend, and maybe one overnight a week and certain holidays. And so there are certain norms. And typically what happens is that the lawyers will negotiate for variations on those norms. This is not an adversarial negotiation where you start off with an extreme position. It sometimes happens in those cases, but that's not an ordinary legal negotiation. If you did that, the other side would walk away because you're just considered unreasonable and you don't know what the norms are. And it's also not a process where you identify the party's interests and then identify a range of options for satisfying these interests. It's a process where you start with norms. And in addition to these family cases, it's used in a wide variety of other types of cases, in workers' compensation cases, in criminal law cases, in some tort cases, in some contract cases, a wide variety. And it's a very common one. Part of the reason that it isn't discussed in a lot of negotiation theory is that it's so routine and it's relatively simple. It's quick often, and it's not as dramatic as these other two models, but it's very common. It's something you should be aware of. And here's a link to an article, the article I described, that discusses these models and also the variables that I'm about to describe here. So these negotiation models, the two traditional models, assume that the following variables are highly correlated with each other, but my study found that that's often not so. So my advice is, instead of focusing on models, I suggest that you focus on variables about whether the parties are concerned about the other side's interests. And you may assume that they often aren't, that they usually or always aren't, but often they are, or at least to some extent they are, for a variety of reasons. Focus on whether they exchange counteroffers, as I said, starting with very extreme offers and making a series of concessions, or using the interest and option approach, or focusing on the norms. Consider whether they're trying to create value or claim value. Creating value is trying to find a result that's going to be in both sides' interest. Claiming value assumes that there's a zero-sum situation where one side's gain is necessarily the other side's loss. Consider whether the negotiators are using a hostile or friendly tone. People often assume that the adversarial model is going to be hostile. In my research, I found that often lawyers used the adversarial model in a very polite, friendly, courteous way. So be careful about making assumptions that these models necessarily have all these variables that go along with each other, that are correlated. Another variable is whether parties, or the extent to which parties use power to get their way, and whether they use law or other norms as the basis of their argument. So I want to talk about a system of litigation interest and risk assessment, which is based on this book that I co-authored with Michaela Keat and Heather Haven. And the book is entitled Litigation Interest and Risk Assessment: Help Your Clients Make Good Litigation Decisions. And the book talks about 3 different elements which you should think about in every dispute. And you can adapt this for transactional negotiation as well. And so the 3 elements you should be thinking about are: the first one is the expected value of the court outcome, which is sometimes often called the BAT value, the value of the best alternative to negotiated agreement, which in a litigation context typically is what you expect the court outcome would be. The second element are the tangible costs of continuing to litigate. So that includes your legal fees as well as various legal litigation expenses, such as for discovery or expert witness expenses, and then intangible costs of continuing to litigate, which are extremely important and which often are overlooked. I'll talk about the intangible costs in a minute. The goals of this LIRA process are to improve party decision-making, and you can see I've highlighted that because it is so important. This is a fundamental ethical obligation of lawyers. There's this popular vision that lawyers make decisions and they're acting almost independently of clients. And sometimes that happens and that can be authorized under the ethical rules. But fundamentally, lawyers have a duty to provide candid legal advice to clients and help them make the critical decisions, particularly decisions about whether to go to trial or to accept a settlement offer. So this is designed to help you fulfill that ethical obligation of lawyers. It's also designed to improve results for parties, your clients, for courts and society by reducing what researchers call decision errors in going to trial after rejecting good settlement offers. There are several studies that have found that a very large percentage of cases, one party or the other rejects a settlement offer that is better than the trial result. So imagine this. Imagine you're representing a plaintiff and the defendant offers you $100,000 or offers your client $100,000 and you go to trial and you get a verdict of $50,000. That result stinks. Your client is getting $50,000 less. He or she has gone through all the additional time and expense and grief of litigation. And they're not going to be happy with you. You're going to be on the receiving end of complaints as to why you went to trial instead of taking that settlement offer. This is a bad result, and it happens a lot. And part of the goal of this process is to reduce the tangible and intangible costs of litigation. If you can settle, by definition, you are saving all the costs that would accrue if you continue to litigate and go to trial. Your job is to be a diagnostician of conflict and to help resolve the conflict. And there are a ton of possible sources of conflict. Some of them are personality conflicts. People just hate each other. They can't stand each other. Sometimes they're underlying conflicts. They may have feuds that bubble up into a dispute, sort of like the Hatfields and McCoys. There may be large stakes involved, and there's just too much risk, and people feel they have to have a dispute to protect themselves. They may have inexperienced lawyers who don't know how to handle cases and value disputes. Parties and lawyers are afraid of looking weak, and so they take on tough positions. Parties don't know or trust each other. Parties don't know their case yet. There's poor communication between lawyers and clients and between counterpart lawyers. There's concern about setting precedent. Sometimes lawyers want to fight. They want to perform for clients and they want to increase fees. Oh yeah, sometimes there's conflict because there are different expectations about the trial outcome. What you can see in this slide is that there are a lot of different sources of conflict. Lawyers assume often that the only reason is this last one, that there are different expectations about what would happen if you went to court. And sometimes that's the case, but a lot of times there are these other sources of conflict. Your job is to try and figure out what the heck is going on and see if you can solve that conflict. And often you can do that much better without going to trial. So how do you use this LIRA process, litigation interest and risk assessment process? You can use it to help clients understand their interests and litigation risks. And you do this by identifying key legal and factual uncertainties and possible outcomes to estimate court outcomes and develop bottom lines. And so what that means is you want to use the legal knowledge that you're learning in these other courses to identify what are the causes of action, what are the defenses, what are the prongs of the tests. So what are the legal issues you need to establish if you're going to go to trial, if you're going to go up on appeal? And you want to find out what evidence you need to establish your case. And by doing that, you want to estimate the likely court outcomes and then develop bottom lines for settlement. And you're going to use this to explicitly consider tangible and intangible costs, which are very critical to clients. And by doing this, by considering all these things, you can help your clients develop wise and effective strategies. In the first instance of proceeding in litigation, assuming that you are in litigation, to help figure out what would be the most effective way of proceeding. And this can also help in developing negotiation and mediation strategies. As I mentioned, there are these intangible costs of litigation, which often are overlooked or undervalued. And here's a link that goes to a blog post that goes into a lot of detail about that. Here are a couple of them. One is stress causing physical and psychological harm. Because litigation is so uncertain and so adversarial, it causes a tremendous amount of stress for parties as well as for lawyers. And this stress can cause clear physical and psychological harm. And there's a tremendous amount of anxiety about it. So this is a concern that a lot of clients have. Clients are often concerned about being stuck in a dispute. They're feeling they can't get on with life. When I was in practice, one of the things that I commonly heard from clients is, I just need to get this over. This is an intangible cost of litigation. They're stuck in the dispute. They have to get this over. Obviously, it can damage relationships, can harm reputations, and it can deprive people of opportunities. The time and money and effort invested in litigation could be invested in all sorts of other things. People could go on vacations. They could spend money on their kids. Businesses lose lots of opportunities by investing so much time and money in litigation. So there are a lot of intangible costs that people don't consider and don't value precisely because they are intangible. And part of your job is to help clients figure out what those costs are, what their interests are that are intangible, and how to value them for the purpose of litigation and negotiation. So critical tasks in negotiation include developing good relationships with clients and counterpart lawyers. And it's important because lawyers and clients often have very different perspectives, and it takes careful work to get on the same wavelength. As I mentioned before, they often have very, very different perspectives, and it's not easy. You can just, if you assume that you just ask clients simple questions and they'll give you simple answers, you will be making a big mistake. It's a challenging process to work with clients, and it's a challenging process for clients to work with you. And it's also important to develop good relationship with your counterpart lawyers, which can have a major impact on how cases work out. So what should you do in practice? Develop good relationships with clients, learn their interests and priorities, which may include the financial outcome, winning or beating the other side, getting rid of a dispute and getting on with life and business, getting respect and apology. A lot of their interest in disputes is because they're feeling disrespected. And if you can provide a way that they can get respect or an apology, that can go a long way towards resolving disputes. And there are a ton of other things. And my strong advice is, at the outset of a case, try and develop a good relationship with a counterpart lawyer. Here's a link to an article that discusses that. And if you have a good relationship with your counterpart lawyer, a case will be a lot easier. You're not going to sacrifice your client's interest. They won't sacrifice their client's interest, but you will avoid unnecessarily and costly disputes that could be avoided. And if you have a bad relationship, if they're not interested in developing a good relationship, then you need to be on guard. You need to be careful. They may try and take advantage of you. So how do you develop a good relationship with a client, with a counterpart lawyer? My advice, get on the phone at the beginning of a case, or now get on a Zoom call Zoom call, I think, is better. So you get to have this visual information and not just over the phone. And ask them where they went to law school. What kind of practice do they have? Where did they grow up? Do they have kids? What are their hobbies? Do they like to travel? What sports teams do they like? And by developing a relationship and learning about commonalities and obviously sharing information like this of your own, you're more likely to be able to work out problems that often come up in cases and in disputes and in litigation. And when problems do come up, if you do have a good relationship, then you'll get on the phone with the other side and say, hey, I got a problem. What's going on? And you'll be able to work it out. If you don't have a good relationship, then it's going to be a lot harder and more expensive for your client. A lot of lawyers will say, you tell me who the lawyer is on the other side, I'll tell you how the case is going to go. And some lawyers I've interviewed have talked about how they've developed relationships with lawyers who have reputations for being difficult and unreasonable. And by developing good relationships, they've been able to make the process work much better for their clients. So what do? You prepare wisely. You make best estimates of expected court outcome that we talked about before, identify key factual and legal uncertainties, conduct discovery and legal research to reduce those uncertainties, and recognize that there will be a range of possible outcomes. Litigation is inherently unpredictable. It's uncertain. Well, it's not unpredictable, but it's uncertain. And what that means is if you tried the same case 100 times, you're not going to get the same result 100 times. You'll get results that will look like a normal distribution curve, a bell curve. And maybe if you have a lot of confidence, there's relatively little uncertainty, the curve will be kind of narrow and tall, and you'll have very few outcomes that are on the tails. But there always will be tails. And if you have a lot of uncertainty, you'll have a normal distribution curve that will be a lot flatter and wider. But in any case, there'll be a range of possible outcomes. And so you need to think about what that range will be. And by doing this research and the discovery, you can help develop that and help advise your clients. You also want to make realistic estimates of future legal fees and the cost of going to trial. This is very hard. There's just a lot that's hard to estimate. A lot depends on how much the parties want to fight. The more they want to fight, they can fight over almost anything. And if they want to be more reasonable, they can only focus on the really key differences between them. You want to help your clients identify and value their intangible interests. And by doing that, you can develop a bottom line, which will evolve over time. So the bottom line is a combination of the expected court outcome, the estimate of future legal fees and costs, and the value of the intangible interests. So, for example, if you're representing a plaintiff, they may say, my bottom line is $50,000 after considering all these factors. What that means is, in negotiation, if they don't get the defendant to offer at least $50,000, it will be worth it to them to go to trial. And I note that the bottom line will evolve. People understandings and calculations of their bottom line may change as they learn more, including what they think the other side is or is not willing to do. And based on this, you can develop a strategy using the models that I described before, and particularly the variables. Now, going forward in the new normal, in the wake of the coronavirus pandemic, people are often going to continue to use video even after they feel safe meeting in person. Professionals and many lay people will be comfortable with it and will appreciate the efficiency of it. And one of the things you will need to do is you're going to need to learn how to manage with that. And of course, you're already doing that and working with clients who may or may not be learning how to deal with it as much. So you're going to need patience dealing with communication problems. You're going to need extra time, especially to talk with clients, and there may be technology problems. You need to be prepared for that. And one of the things that may happen is that negotiation and mediation may be broken into stages. Often mediation takes place in a single one-day process. And that could be problematic. It may be broken into multiple stages over a period of time. Now, I also want to briefly talk about competition. Some of you may be involved in some competitions. One of the things is you should always remember that your goal is to protect your client's interests. Your goal is not necessarily to reach an agreement. I've been a judge in many competitions, and one of the things you want to avoid is having judges say, this seems like a love fest. You should be as cooperative as is appropriate, but you should always be protecting your client's interest. Judges have very different philosophies. Often professors and practitioners have different philosophies, and different academics and different practitioners have different philosophies. So your goal is to try and produce something to act in a way that will satisfy people with a variety of different perspectives. So one of the things that I encourage is what is called the tit for tat approach, which means you start cooperatively, and then you mirror your counterpart's responses, cooperative or adversarial. If they respond in a cooperative way, you continue to be cooperative. If they respond in an adversarial way, you don't let them get away with it. You show that you're not going to get pushed around, but you also show that you're willing to be cooperative if they will be. And so one way of doing that is you can tell them that you're willing to do it the easy way or the hard way. You prefer the easy way, and your client prefers the easy way, but you can do it the hard way if they want. Don't say, my goal is to reach settlement. My goal is to reach an agreement. What you should say instead is, my goal is to reach agreement if we can satisfy both sides' interests. You just say, my goal is to reach settlement, then it looks as if you're desperate to reach settlement, and you'll accept something that won't necessarily be in your client's interest. You'll accept a bad, unfavorable agreement. If you say, well, my goal is to reach settlement if we can satisfy both sides' interests, then it reflects that you're only going to do it if it satisfies your client's interest, and you should say both sides' interests, or else it will seem that you're going to be adversarial and it will turn them off. Finally, let me show you some resources that you may want to check out. Here's a brief blog post I wrote, this letter to Kelly, with advice for law students, especially for first-year students, but any law student might be interested. A longer piece, a law review article with unsolicited advice for future and current lawyers. Another article that really relates to what we've been talking about here is good pretrial lawyering, planning to get to yes sooner, cheaper, and better. Another is a book I wrote on lawyering, planned early negotiation, how you can get good results for clients and make money, typically two major interests of lawyers. Stone Soup interviews. This is about a process that some faculty use in their courses where they assign students to do interviews of practitioners or parties. If you want to do an independent study course where you are going to do your own interviews, which again, Zoom can help you do, this link will describe how you can do that. There's a link here with more information about this LIRA process, a link with more blog posts and videos to provide details. There's an Indisputably blog that has a lot of law professors who focus on ADR and have posts. And I'm happy to talk with you or talk by Zoom. If you want to email me, here's my email address. I hope you found this valuable and useful, and I wish you well in your law school and legal careers.